Hello, my name's Tom Lazar. I'm a barrister at Keating Chambers, and I've decided to start doing these regular summaries of cases handed down in the TCC in the hope it might help some of you to keep up to date with recent case law. And the first case I'm going to be dealing with is a case handed down on the 7th of September, Downs Road Development and Laxmanbhai Construction. This is a case that concerned a JCT design and build contract, which involved the demolition of existing buildings and the construction of 79 residential units on a site in Hackney. Now, the employer's agent adopted a payment process where it would issue an initial payment notice in response to an application for payment from the contractor. That would be for a negligible sum with no detailed backup. A week later, it then revised that payment notice for the sum that it really considered to be due on the relevant payment date. Now, the contractor declined to take the opportunity to issue a smash and grab adjudication for 1.8 million, which would have been due if the initial payment notice was invalid. Instead, they tried to conduct a true value adjudication. Now, in that adjudication, the employer tried to raise a counterclaim of set-off against any sum that was held to be due. But the adjudicator decided that he only had a very narrow jurisdiction, only to deal with the issues on the application for payment, and refused to consider the counterclaim. The net result of this was an award of around £100,000 for the contractor, although the counterclaim, which was rejected on grounds of jurisdiction, was put at more than that, at around £150,000. In that context, the contractor threatened to suspend the works if the £100,000 was not paid, and the employer commenced proceedings for a declaration that the decision was unenforceable, and so the contractor had no right to suspend. Now, that claim had the potential to blow up in the employer's face when the contractor argued that if the decision was not enforceable, then there was no valid payment notice, and so the full sum would become due. Responding to that, the employer tried to say that the decision was severable, and that the decision in respect of the valuation was enforceable, but not the order to pay because of the failure to deal with the counterclaim. Now, His Honour Judge Eyre set out the issues in that context as follows. First, whether there was a valid payment notice. Second, whether the adjudication decision, whether the adjudicator was right to refuse to deal with the counterclaim, and then what the effect of his judgment on those issues would have on the position of the parties. So the first point was whether the first payment notice was a valid payment notice under the contract. Well, no, it absolutely was not. We go to paragraphs 37 and 38. So what does a valid payment notice require? Well, under the Act, it has to specify the sum that the payer considers to be or to have been due at the payment due date in respect of the payment. And second, the basis upon which that sum is calculated. And that is something that under the JCT contract was repeated. So first, the sum that the payer considers to be due, and second, the basis upon which it's calculated. And the judge went on to consider the jurisprudence in this area. Now, it's not necessary to go into the deep detail in terms of what the parties said on this point, but the principles are essentially that first, and I think we can go down to this, the principles are first, that the payment notice has to reflect what the employer genuinely considers to be due. And second, it's in sufficient detail if it's enough to set an agenda for a subsequent true value adjudication. Now, the judge was satisfied that the interim payment notice, if we're going to call that, the initial payment notice, didn't comply with either of these requirements. And here he deals with them at paragraphs 47 and 48. It cannot realistically be contended that the payment notice 34 accurately stated the sum which the employer considered to be due at the payment due date. That is evident from the fact that the covering email said that a further notice would be issued, and there were other reasons too. As to the sufficiency of the notice, well, what was done was not sufficient to show the basis of the calculation because in the absence of any accompanying material, the notice does not show how the employer had arrived at the crucial figure of the gross valuation. So the payment notice is invalid, but what about the failure to deal with the counterclaim? Well, the test is set out in paragraph 55. Sorry, 53. Now, the judge goes on to consider Mr. Justice Coulson, as he then was, his judgment in Pelon, and goes through the propositions there. And if you want to see the detail there, then you'll be able to see this marked up copy on the post that I'm sharing on LinkedIn. But the judge helpfully summarises the test at paragraph 53 here. The test to be applied is that a deliberate failure to address a material issue which was before the adjudicator on a proper view of his jurisdiction will be a breach of natural justice. An issue will be material for these purposes if it is shown to have had the potential to make a significant impact on the overall outcome of the adjudication. So again, we don't need to go into the detail of how these arguments were deployed by counsel in this case, but it was held at paragraph 61 that by refusing to deal with the counterclaim, the adjudicator took an unduly narrow view of his jurisdiction. The exercise in which he was engaged in his decision was to address the sum due in a particular payment cycle. He set out a conclusion as to the correct figure and stated that interest was payable on the outstanding balance. The counterclaim was being put forward as a matter which the employer said reduced the amount which was due in that cycle. It was accordingly being raised as a defence in respect of the matter in issue in the adjudication and in respect of which the adjudicator had jurisdiction. If the adjudicator had considered the capping beam and had concluded that the defence did not operate to reduce the amount due, his decision would have been unimpeachable. The distinction between an adjudicator addressing a defence and concluding that it fails, and an adjudicator deliberately declining to address a defence can be a narrow one, but it is a real one. I am satisfied that by deliberately deciding not to address this defence, the adjudicator was declining to address a defence which the employer was entitled to advance and entitled to have considered by the adjudicator. So, where does that leave the parties? If the decision is unenforceable and there's no valid payment notice, then conceivably the £1.8 million was due on the initial application for payment. But before we get into that, we have to then deal with the employer's what I initially thought was rather a desperate attempt to separate the decision between an enforceable element related to the application, the decision on as to the sum due on the application, and the unenforceable element, the order for payment, which comes from the failure to deal with the counterclaim. Now, the judge here spent a great deal of time and effort going through the jurisprudence on this issue, and as I was going through it, I became increasingly concerned that the judge was going to find that the decision was, in effect, enforceable. Now, if you have a look if you have a case on severability, I think it is worth bearing this case in mind because the way that he's gone through the jurisprudence here it's extremely thorough. But I think it's fair to say that it boils down to a few principles that you first get from Mr. Justice Edward Stewart in Working Environments and Greencoat. The extracts here at paragraph 78 to 79. So the general principle was that a decision cannot be severed where only one dispute or difference has been referred. He said that the rationale underlying this principle was that where a single dispute or difference has been referred, it will generally be difficult to show that the reasoning in relation to the part of the decision that is being sought to sever had no impact on the reasoning leading to the decision actually reached, or that the actual outcome would still have been the same. If this is the case, the part cannot be safely severed from the whole. He said that in this case, the decision didn't conflict with that principle, because where, in the case of a referral of a single dispute, additional questions are brought in and adjudicated on, whether by oversight or error, there should be no reason in principle why any decision on those additional questions should not be severed, providing that the reasoning giving rise to it does not form an integral part of the decisions as a whole. Then we go on to add the decision of Mr. Justice Pepperell in Willow Call, where he agreed with the judgment of Mr. Justice Edward Stewart. He said, well, in my judgment, the proper question is not to focus on whether there's a single dispute or difference, but upon whether it's clear that there is anything left that can be safely enforced once one disregards that part of the adjudicator's reasoning that has been found to be obviously flawed. Such analysis need not be detailed, and in many cases it may remain the position that the entire enforcement application should fail. It would, however, further the statutory aim of supporting the enforcement of adjudication decisions pending final resolution by litigation or arbitration if the TCC were rather more willing to order severance where one can clearly identify a core nucleus of the decision that can be safely enforced. So pausing there, you can see how conceptually there would be no real reason why a decision on the payment application could not be entirely separated from the issue relating to the counterclaim. But the judge took a different view, an interesting view, which was in other cases, the other cases in the jurisprudence, he was dealing with, or the judges were dealing with cases where a contractor was bringing a claim, trying to get money for a series of works, and what was decided was that the contractor could have some of the money, but not all of the money that was being claimed. But here you have an employer who was trying to accept a relatively advantageous valuation while maintaining as yet undetermined right of set-off to prevent payment against that award. And on the merits, the judge just didn't like it. And go down to paragraph 96. So this is what he held on the point. The starting point is to consider the particular adjudication. Here the adjudication was concerned with a single issue, namely the amount payable to the contractor in light of interim application 34 and the exchanges which had followed it. The stages in the adjudicator's reasoning are properly to be seen as a part of the process leading to a single conclusion, rather than a series of separate and freestanding decisions, with each being intended to be binding in its own right. He went on, it would in my judgment be artificial and inappropriate for the court to stop at any particular point in the chain of reasoning as set out by Mr. Entwistle and conclude that the decision was binding up to that stage, but not as to the stages which followed. To do that would be to treat the matters which the adjudicator chose to set as the reasons why he reached the ultimate conclusion as if they were separate findings. The employer succeeded in showing that the adjudicator's ultimate decision on the single dispute he was addressing is not enforceable, and in the circumstances here, it cannot be said that there is anything remaining which can be safely enforced. So, no valid payment notice. No part of the decision is enforceable. Surely the contractor gets his money. Well, sorry for the anticlimax, but no. Neither side had sought any relief in relation to these questions in the pleadings. In the light of my conclusion that no element of the decision is enforceable, the question of whether the employer would have remained liable to pay the notified sum, subject to subsequently seeking return of any overpayment, notwithstanding the decision, is academic for the purposes of these proceedings. Interesting though Mr. Mort's contentions were, I do not need to address that issue any further. So we're deprived from what we think should have been the outcome of this case on the basis of a pleading point. So that's this case. And what are the lessons that we get from it? Well, perhaps the first one is that the employer's agent needs to stop messing around with payment provisions. We all know how important it is to follow not just the letter of the payment provisions, but also the spirit that it is intended to produce. And what about the contractor? Well, I'm sure that this is the party that feels most aggrieved by the situation. They tried to do the right thing by having a true value adjudication instead of going for a smash and grab. And that's advice that I've given in the past, to say, well, if you think you're strong on the underlying merits, go with that. It will ultimately cause less aggro between the parties and you'll have a decision that you can take forward. But the contractor was let down by an adjudicator's error on the issue of jurisdiction. And now, because of the outcome, because we don't get the punchline that we think that maybe the contractor should have deserved, the contractor's no further forward either on the true value of the claim or having spent a great deal of time and money on argument, adjudication and litigation. So sadly, the lesson for the contractor here is that perhaps in hindsight they'd have been better off going with a smash and grab adjudication. I hope you enjoyed this review of the case. If you did like it, please share it and I'll provide another one soon. Thank you very much.